Hi, I hope you can hear me and see me. I'm Stephen Tromans, and I'm introducing and chairing this webinar today, Central Issues for the Central Region. You're very privileged because this is the first of our series of regional webinars. We've run others, as you may know, but we're focusing in this one on the Central Region of Birmingham and the Midlands. So if we could possibly move on to the next slide, John. That's great. So there's the three of us, handsome chaps that we are. That's who you're getting this afternoon in that order. So I'm chairing it, and then Gethin, and then John. And the programme, if we can move on to the next one. So I'm going to be saying a little bit about some environmental issues in the region. And I want to talk a little bit about some cases dealing with challenges, judicial review challenges to major infrastructure schemes. There's been some interesting law on that, I think. Gethin is going to talk about the very topical issue of change of use, and then John has a number of other issues which you can see he is listed there, all of them important, a number of Court of Appeal decisions that he's going to cover. So I hope you'll find that to be of interest. I should just say that if you're following this, there is at the end of the slides a list with citations of all the cases we're going to mention. So if you mention a case, don't worry about trying to note down the name or whatever. You will find that at the end. We're also recording this, and it will be available afterwards if you want to watch it again or recommend it to your friends on our Chambers website, where you will find also a lot of other potentially useful information. We have various podcasts, webinars, our newsletter, and other various eccentric musings which you can access through our website. So I hope you'll find that to be helpful. I'm going to move on because we want to leave as much time for the law and for questions as we can. So I'm going to talk a little bit about environmental issues in the region. Like many other areas, Birmingham had its school climate strike, as did Bristol and lots of other cities. Plainly, there's a big groundswell of opinion amongst young people and not so young people that something needs to be done about environmental issues. And moving on, a number of things to say around Birmingham. Birmingham, of course, like many other cities directed by government, in fact, formulated proposals for a clean air zone to control emissions from traffic in the city. That was due to be coming into play this year, has been postponed until June of next year, but is still on the cards. Unlike some cities, I noted in the Times reported last week that a number of cities, I think Leeds was one of them, had, in the light of COVID, dropped their proposals or shelved them for clean air zones. That's an issue which I don't think is going to go away for those cities that have deferred them. Client Earth is still, I think, very focused on this issue, and I'm fairly confident that if local authorities are not seen to be doing enough, then certainly there may be more litigation in store. But anyway, Birmingham is going down the right path. It has, as you may be aware, a draft transport plan 2031, and again, like many other parliaments and cities, Birmingham declared a climate emergency in the summer of 2019. There have been many other, of course, cities which have done that, and also the Scottish, Welsh, and UK parliaments. And you might say, well, what's the point of a climate declaration? Does it mean very much? Of course, in itself, it doesn't mean very much other than a recognition that there is a serious problem to be addressed. And of course, following on from that, there may be implications for planning decisions, for planning, for budgeting, for investment, and for monitoring, all of those things. And Birmingham has followed through on that with its council plan. It describes itself as a city that takes a leading role in tackling climate change, and last year created the Route to Zero, the R20 task force, to take forward that issue. it's going to be a very, very difficult and very challenging path, clearly. And more broadly, the West Midlands Combined Authority formulated its own plan, of course, Birmingham being one of the constituent authorities of that plan for greenhouse gas reduction of around 13% a year up to the period of 2041, and under the hashtag WM2041. That's going to be very costly, about £40 billion it's estimated to cost to achieve that. And it's quite plain that that's not going to happen without central government support and also without changing, actually, quite an important part of the region's psyche, which is all based around the automotive industry. So it's going to be fascinating, I think, and challenging to see how that plays out in future years. So that's just a snapshot of where we are. We may get some further comments on that in questions. I should have said, and forgot to say, by the way, that you'll be familiar with Zoom. There is a Q&A facility. So if you have a question as we go along, please type it in, ping it off to us. We will do our best to deal with it in some way, if not verbally, then online or offline. So we don't want you to have questions that aren't addressed in some way. So I'm going to move on to the second aspect of my presentation, which is to look at the various challenges that there have been and are to major projects. So we're talking, of course, things like Heathrow, HS2, and major infrastructure. And if we move on to the next one, so the key kind of themes coming out of that are climate change, plainly, SEA, EIA, and habitats. I mean, you'll note that 3 of those are European related. Remains to be seen, of course, how European law pans out come the end of this year when the withdrawal period ends and the government is free to do its own thing on some of these topics. But, you know, for the time being, that's how the law is. And of course, for claimants in these cases, these are actually very attractive ways of putting their case because they're much more generally hard-edged than trying to bring a claim based on normal principles of judicial review, irrationality, unlawfulness, and so on. And as we'll see, you know, the targets tend to be, in particular, major transport projects and major energy projects, but that's not necessarily, of course, an exclusive list. So the first case, I'm not going to deal with every case here because there wouldn't be time. I'd be stealing too much time from other people, but I'm just going to focus on a couple which are important and recent and I think worth mentioning, and then draw some conclusions from them. So the first is the well-known case Plan B Earth, sometimes called Spurrier. Mr. Spurrier was the claimant at first instance, that then switched really to being led by Plan B Earth, and Secretary of State for Transport. This was the challenge to the airport's national policy statement, providing policy support for a 3rd runway at Heathrow. That, as you'll recall, failed comprehensively in front of a divisional court, but on limited grounds was strikingly successful in the Court of Appeal, in particular the climate change ground, which was whether the adoption of the national policy statement was lawful, given the UK's commitment to the emissions reductions agreed under the Paris Agreement made pursuant to the UN Framework Convention on Climate Change. And the Court of Appeal, I think, maybe to some people's surprise, said yes, it was unlawful for various reasons, focused particularly on 2 sections of the Planning Act 2008, 5.8 and 10.3, but in effect, really making the point that the government should have considered its own policy on climate change and the Paris Agreement, and had not done so. Indeed, it was said by the court, had been legally advised by its own legal advisors that it should not and could not take those matters into account. And that was simply, it was said by the Court of Appeal, wrong, and the ANPS was therefore quashed effectively. So the government did not appeal that. I mean, plainly political factors were at play here, including, presented quite a convenient way out from lying in front of the bulldozers for the Prime Minister if that scuppered Heathrow expansion. So the government decided not to appeal, but Heathrow Airport Limited, HAL, did appeal, and the hearing was held in the Supreme Court a couple of weeks ago. Some of you may have watched bits of it. I watched bits of it. My prediction is that the Supreme Court may agree with HAL, judging from some of the interventions made, particularly by Lord Sales and Lord Leggett. It looked to me like Heathrow Airport's arguments were gaining quite a bit of intellectual traction there, but who can say? We have to wait and see what the court says. But the case does, I think, illustrate the potency of some of these grounds, and also the unpredictability that grounds which the divisional court had dismissed as being basically just unarguable, hopeless, gained the support of the three judges in the Court of Appeal. So we'll wait and see what the Supreme Court says on that. So that's one case to be aware of and keep an eye on. Another case does have a Birmingham flavour, because of course it concerns HS2 between London and Birmingham. Chris Packham, becoming quite a litigator now against the Secretary of State for Transport, really trying to attack not the planning permissions and so on given for the HS2 project, because that they were given long ago pursuant to the parliamentary and statutory processes, but the government's review informed by the Oakerby report as to whether it would proceed with HS2 as a project. And the government decided yes it would, in light of Oakerby's recommendations, and that was what was under attack by the Chris Packham. And a number of quite interesting issues come out of that. One is just the sheer speed with which some of these cases now get determined, actually. When you have these major infrastructure challenges, they do get through the courts at a fairly rapid pace. So, for example, the divisional court, two-judge divisional court, heard this case at first instance on the 3rd of April, indicated they were going to chuck it out, not give permission. They gave reasoned judgment for that on the 6th of April. By the 8th and 9th of July, that was in the Court of Appeal, and the Court of Appeal gave judgment on it by the end of July. So that's pretty meteoric speed in legal terms to get these things through to Court of Appeal level. It indicates the courts are giving them a strong priority, because plainly the important implications when a major infrastructure scheme is under challenge. So what are the takeaway points from the case? I think the first is the question of timing. The divisional court had said that the claim was out of time. It had been brought within 6 weeks and 3 days of the decision. So well within 5 weeks or more within the 3-month period for judicial review. But the divisional court, taking a pretty hawkish approach, applied a number of cases which go back to a case called Finn Kelsey in the Court of Appeal some years ago, stressing the need for swiftness when challenging planning decisions, and applying sort of presumptively by analogy with the planning legislation a period of 6 weeks. There was another case called Gerber, Court of Appeal decision, which sort of followed that, and the divisional court adopted that and said, well, this is over 6 weeks, if only just. It should have been brought more promptly. We're not giving it permission. The Court of Appeal took a much more accommodating approach to that. They said that it was materially different to the Finn Kelsey type of case. This was not a challenge to a statutory process. It was a challenge to the exercise of common law powers by the ministers to review a project. There was no statute involved. It was simply common law. It was pure judicial review. They had 3 months, well, they had to act promptly, but in any event within 3 months, so well within the 3 months. And the court said there was no reason to think they hadn't acted promptly in the circumstances. They needed to see the decision. They needed to see the terms of the Oakerby report, which was published at the same time of the decision, in order to formulate their challenge. And therefore they were okay in timing terms. Secondly, the issue of the standard of judicial review. This is a very important issue that most cases these days on challenges have quite a lengthy section looking at the court's jurisdiction and how challenges are framed. And basically they've held the line on saying that you're back in the normal principles of rationality, light touch review, that you're not, the government isn't exposed to any more exacting a standard of review despite the massive nature of the project. Indeed, perhaps because of the massive nature of the project, because these are, as the court puts it, macro political decisions, which courts really not intended or equipped to interfere in. So you're going to have to find, and the Court of Appeal makes this plain, you're clearly going to have to find unlawfulness in some way in terms of bad faith, improper motives, manifest absurdity, or something like that in order to get there. There's a very helpful comment by the Court of Appeal, paragraph 51 of the judgment. And finally, there was an issue on environmental assessment which failed. I think that's quite fact specific, so I won't spend time on that. But also the climate change ground. Interestingly, Mr. Packham, his barristers, understandably, relied very heavily on the Plan B case and what the Court of Appeal had said there, whereas the decision on climate change in Plan B had been really just a throwaway few lines in a couple of paragraphs. The Court of Appeal in this case dealt with climate change much more fully, and they distinguished what they'd said very shortly before in Plan B. It wasn't an analogous case, and in particular some quite interesting comments in paragraph 102 about rejecting a submission that in any major infrastructure event or application where climate change could be relevant, it doesn't follow that climate change is automatically a material consideration. It may be or it may not be, and if it is, the weight to be given to it is a matter for the decision maker, not the court. So next slide, that sort of leads into neatly the final case I want to mention, Client Earth against Secretary of State for Business. That was the decision by Andrea Leadsom, I think she was then the Secretary of State, to give permission for two huge gas-fired generating station units at Drax, which essentially were sort of tended to be a transitional measure, really, I suppose, on the path to a low carbon future, but were going to emit huge amounts of greenhouse gases over their life. The examining panel for the DCO recommended refusal on the basis of the environmental impacts of those greenhouse gases. The Secretary of State accepted there would be adverse impacts, but concluded they were outweighed by the energy need for the new units, and relied upon the National Policy Statement EN1. The panel had said that EN1 required need to be demonstrated in quantitative terms. You had to show that there was an established quantitative need for this amount of energy from these units. The Secretary of State said, no, that was wrong. All that EN1 required was a qualitative need, simply saying we need more energy. We desperately need more units of electricity, and no figures put on it. And the court said that was the correct approach, that the Secretary of State had been correct to say that EN1 did not require need to be demonstrated on a rigorous quantitative basis. And indeed, that may well be right, because of course part of the DCO system was intended to do away with detailed arguments at the examination about the need having to be demonstrated for a particular project. The need is taken from the terms of the National Policy Statement. Also, following on from what I said on the previous case, the court said that the weight to be given to the greenhouse gas emissions was a matter for planning judgment for the Secretary of State. However, there is an appeal pending to the Court of Appeal, so who knows? We'll wait and see what the Court of Appeal has to say about that. So we're getting there. Next slide. just to say, to flag up some other challenges which are coming forward, which could be interesting. We don't have decisions on them yet, but there were cases worth following, I think. So there is a lot of litigation, has been a lot of litigation over the biggest incinerator in Europe, the Rivenhall project in Essex. That's to be heard at some point, I think, this month. There is the Good Law Project, Jolly and Morm's outfit, challenging the national policy statement. Again, that's achieved some traction already, in the sense the government's agreed to review the Energy National Policy Statement, EN1, but the Good Law Project is saying that the government ought to suspend it, the current NPS, whilst it's reconsidering it, so people wouldn't be able to rely on it as the Drax scheme had done in the meantime. So that would be very interesting, I think. There's a case I'm involved in with Victoria Hutton from my chambers, the Good Law Project again, a judicial review challenge to the government's air quality policy, saying that air quality standards need to be urgently reviewed because of a possible link between COVID-19 and poor air quality. There's also, I think, another very hot potato, the Woodhouse Deep coal mine proposed in Cumbria, West Cumbria. Secretary of State has prevented the local planning authorities taking a view on that, deciding whether to call it in. One can see that that's one's going to probably run as well. That's extracting coal for industrial purposes, cement making, coking, etc. So I think we're nearly there. So what points can we glean from all this? First of all, I think a growth in environmental judicial review, particularly at a big level, big issues like climate change, with new players coming in. I think if you went back, a decade, then really you had Greenpeace, you had Friends of the Earth, you had Richard Buxton representing local clients, you had one or two wealthy individuals or committed individuals like Lady Berkeley taking cases, sometimes to very good effect. But now, there's really quite an array of new players in the claimant field. So we have the Good Law Project. I mentioned, a sort of portmanteau organisation taking all sorts of cases. There is Client Earth, focused particularly on air quality and on climate change, but not exclusively that. There are ad hoc organisations like Plan B Earth, quite small, but they run cases. There is Wild Justice with Chris Packham and his friends taking cases, particularly on the nature conservation area. So a lot of new players, and they raise a lot of money through crowdfunding, essentially. So there's no real bar to this sort of litigation now in terms of costs, because they're all Aarhus cases. So the exposure to the government's costs is generally capped to a manageable level. It's very easy, I think, for organisations like this to raise 100,000 or so in almost no time by crowdfunding. And indeed, if you look at the Good Law website or others, then you'll see they're quite content to put out what the results of their crowdfunding is. So I think that's new. That there's no real financial stop on people litigating for those reasons. And secondly, I think you can say we remain with very liberal standing rules. It's a good thing. I think generally it's perfectly possible for new bodies to be set up and challenge government action. As we've seen, the courts also are not, I think, harsh, particularly now on timing in every case. So I think that sort of explains some of the factors. On the other hand, of course, the courts are holding quite a firm line on the standard of review, not moving out beyond the established parameters of judicial review, which are quite narrow in their scope and make it quite difficult actually to formulate a good challenge in many cases, because the courts are simply not interested in the merits. They're interested in whether something's gone wrong in legal terms. And finally, there's no time to talk about it, but we of course have a general review by the government of the judicial review system. That's created a lot of concern within the bar, solicitors and legal circles. There's clearly quite a groundswell of feeling against fat cat lawyers. I don't think any of us are fat cat lawyers here, but you know, taking cases to feather their own nests, as the government would see it, or for goody purposes. That's of course misconceived, but remains to be seen what the government may or may not do in terms of reforming access to justice in judicial review. But that's the position as it stands at present. I've used up my allotted time, so I'm going to shut up, close myself down, not totally, but so you can't see me, and then pass over to Gethin, who's going to talk about the important topic of change of use. So do put the questions up as you wish, and I'll try and address them as we go through. So I'll say cheerio for now. You'll see me again at the end.
Thanks very much, Stephen. Good afternoon. So I'll be talking about some recent changes in respect of changes of use. First of all, addressing the Town and Country Planning Use Classes Amendment England Regulations 2020. These regulations were laid before Parliament summer recess, or the day before Parliament summer recess, on the 21st of July 2020, and then came into force at 10 AM on the 31st of August 2020, the day before Parliament reconvened. The changes, in short, made by the regulations are that they create new use classes in relation to England. And the government has explained, and I quote from the impact assessment, that these reforms to the use classes are primarily designed to help support vibrant, mixed-use town centres. They apply to all uses of land and buildings in town centres and elsewhere across England. Although it's important to bear in mind that these regulations do not apply to Wales. By way of very brief context, planning permission is required, as we all know, for development as defined in Section 55 of the Town and Country Planning Act 1990, and the making of a material change in the use of any building or other land is normally defined as development and therefore requires planning permission. However, Section 55(2)(f) of the 1990 Act allows the Secretary of State to make an order which groups different uses of buildings and other land into use classes, so that a change of use within a single use class does not constitute development and therefore does not require planning permission. It's a very basic proposition that you'll be aware of, but it's important to bear in mind because it has key implications for the extent of control that a local planning authority may exercise over the use of land following the implementation of the 2020 regulations, which I'll be turning to shortly. Now, I don't think it's any exaggeration to say that the 2020 regulations make radical changes, not just to the Use Classes Order 1987, but to the planning system itself. And the regulations are a self-described complete overhaul of the Use Classes Order. Equally, I think it would also be not too great a leap to see the 2020 regulations perhaps as the tip of the iceberg in terms of reforms to the planning system. Hopefully in this metaphor, the planning system is not the Titanic, but the 2020 regulations are just the beginning of the process of radical revolution which has been trailed in the government's white paper published in August 2020. And I think the 2020 regulations reflect, for better or for worse, the kind of deregulation which can be expected in the near future. In particular, so the 2020 regulations epitomise the two overarching policy aims which are set out in the white paper for the future reform of the system as a whole. The first being simplification of the planning framework, and the second being a movement to what's termed a rules-based approach, which I think impliedly really means automatic, rather than a discretion-based planning decision making process. So therefore, I think when considering the 2020 regulations impact, it should be borne in mind that the context in which the Use Classes Order will sit in the future, in terms of the wider planning system, will itself be quite different. Please could I have the next slide, John? As you'll be aware, the use classes under the 1987 regulations were broadly grouped into four overarching class categories. A classes covering retail, food and drink and consumption, B classes covering places of work like offices, manufacturing, C classes residential, and D classes covering institutions and leisure uses. The 2020 regulations amend and simplify the system of use classes in England by creating new use classes which are contained in the new Schedule 2 to the use classes order. Now, the amorphous Class E of commercial, business and service has swallowed up all of the diverse use classes which are set out on the slide. So, for example, a cafe or a restaurant can now be converted to a gym or vice versa, and that change of use no longer constitutes development at all. And as you can see, this is an extremely wide-ranging use class. And this single change obviously has the biggest impact on the use classes order in 1987. It facilitates significant changes to the high street, as well as out-of-town centre industrial parks in particular. And on the government's estimate, the number of buildings in scope of the new commercial, business and service use class is around 1.5 million. Class F1, please go to the next slide, John, is more of a rebranding of Class D1 than a fundamental change. And I set it out on the slide there for completeness. Class F2, like Class E, is a combining of relatively disparate current use classes into a single new class, broadly labelled local community. And this combines Class A1 shops, Class D2 hall or meeting places, and indoor or outdoor pools, skating rinks, and other recreational uses. The placement of the Class A1 shops in Class F2 rather than E is said to be an attempt to protect smaller shops outside main shopping areas, particularly in rural communities and large residential estates. In its impact assessment, the government has stated that F1 and F2 classes are intended to ensure that those uses which are important to local communities have some protection through the planning system, because the scope to the change of their use without permission is more limited than Class E. Although they're more limited in scope than Class E, by contrast, Class F2 is still nonetheless very broad. In terms of other use classes that have been implemented, the residential C classes, general industrial B2, and storage and distribution B8 use classes remained completely untouched. Although I'll come on to briefly, there have been some changes in respect of permitted development rights for Class C in particular. A number of uses have been erased from existence completely. There are a number of uses identified in Article 3.6 of the Use Classes Order, which are not use classes anymore at all. And these include the former A4 drinking establishments and A5 hot food takeaway use classes, cinema, concert, dance and bingo halls, which fell within the former D2 use, as well as venues for live music performance. The consequence of that is that any change of use to or from those uses requires planning permission, ensuring greater control over them. And the government has expressed concern in particular in terms of policy underpinning for this is that hot food takeaways can encourage healthy eating, or live performance music venues can create noise late at night. So those particular amenity impacts have been the focus of the Article 3.6 exceptions. In terms of implications, well, the key implication is the significant shift in control away from local authorities into a significantly less regulated environment. Plainly, the amenity impact of a cafe or restaurant is significantly different to that of an office, which is different to that of a creche, which is different to that of a shop, and so on. But a single unit on the high street or an industrial park could now rotate between all of those uses without being subject to planning control. There are also potentially wide-ranging secondary or indirect impacts on other processes, such as valuation. Equally, however, the flexibility is of course not without its benefits. The high street, retail and hospitality sector are in the throes of well-publicised challenges with no abatement in sight. Moreover, there is also bound to be a marked decrease in the demand for B1 office units in particular, given the now established trend of home working. Therefore, the opportunity to switch more easily between different uses so as to pursue new business opportunities may have a positive impact in reducing the numbers of vacant properties. So, can local planning authorities take back some control? Prospectively, conditions may be attached to an individual development's planning permission to restrict a change of use within a given class, such as Class E, for example. However, the imposition of such a condition must meet the test of being necessary, relevant to planning, relevant to the development, enforceable, precise, and reasonable. I think it's also worth noting that the Secretary of State has a power which was introduced pursuant to the Neighbourhood Planning Act 2017 under the now Section 100ZA of the 1990 Act to restrict the power to impose planning conditions in England. It's not beyond the pale to imagine that power being exercised to limit the ability to use planning conditions in that way. But for the moment, at least for forthcoming future developments, conditions properly imposed are really the main, if not in effect, the only way that LPAs may take back some control over changes between these sorts of uses. Article 4 directions aren't a route to clawing back some control of changes within a new use class because they only apply to permissions granted under the GPDO because the use class, as identified at the outset, exempts certain changes of use from requiring planning permission in the first place. Article 4 doesn't help, and carefully drafted local plans, again, prospectively, could be a tool in the sense that there'll be a material consideration as to whether, for example, permission for a Class E development is to be granted in the first place in a particular case, but again, won't really touch movements within classes. The 2020 regulations also contain transitional or savings provisions that apply from the 1st of September 2020 to the 31st of July 2020, and that period is referred to in the language of the regulations as the material period. What the transitional savings provisions do is preserve the old use classes for the purposes of the General Permitted Development Order 2015. There are a number of existing permitted development rights which grant planning permission, allowing change of use between use classes, and the saving provisions retain the effect of those rights based on the use classes as they existed before the 2020 regulations came into force. But revised permitted development rights will be introduced with effect from 31st of July 2021. No draft regulations have yet been published, so it's only possible at this stage to speculate as to what shape the permitted development rights might take. Obviously, a significant unknown is what the government will do in respect of office to residential permitted development rights. B1 as a use class no longer exists. I think it would be extremely surprising, but perhaps theoretically not entirely out of the question for the government to permit Class E to C3 development. That was obviously would have wide-ranging implications. But the position of planning regulation in respect of converting commercial business property to residential is significant for obvious reasons, and will likely only have more importance given the impact of COVID-19 on commercial properties and on the hospitality industry. And landlords may well very much welcome looser regulation allowing residential conversions. At this stage, as I said, one can only speculate as to what the position may be, say that it will involve a significant degree of deregulation. And indeed, the only clue at the moment as to what might happen is the text of the white paper itself, which makes clear that legislation is proposed to widen and change the nature of permitted development so that it enables popular and replicable forms of development to be approved easily and quickly, supporting what is termed gentle intensification, which may be something of an oxymoron. So in terms of other discrete changes to permitted development rights, there have been a number of changes to the GPDO pursuant to 3 sets of regulations, which I'll very briefly summarize in turn. The overarching thrust of these regulations is to make it, in particular, easier to build upwards by extending buildings towards the sky. So first, the Town and Country Planning Permitted Development Miscellaneous Amendments England Coronavirus Regulations 2020 introduce a new Class A into the GPDO, which is new dwelling houses on detached blocks of flats, which grant the right to extend purpose-built blocks of flats upwards by 2 additional stories. The blocks of flats themselves must consist of 3 stories or more before the extension and cannot have a total height of 30 meters or more with the additional 2 stories. The regulations also require that anyone seeking to use permitted development rights to change the use of premises to residential will need to ensure that all habitable rooms have adequate natural light. So those regulations have particular implications for town centre and urban areas. The second set of regulations, the Town and Country Planning GPDO England Amendment number 2 order, contain a number of new classes. Class AA, which is the enlargement of dwelling house by the construction of additional stories. Class AB, new dwelling houses on terrace buildings in commercial or mixed use. Class AC, which is new dwelling houses on terrace buildings in use as dwelling houses. And Class AD, new dwellings on detached buildings in use as dwelling houses. Each class allows for the construction, again, of up to 2 additional stories of residential accommodation, or 1 story if the existing premises itself currently is only 1 story, subject to the prior approval of specified matters by the LPA, and other certain limitations, including restrictions, again, on overall height, and a requirement that the old building has to be constructed within a particular period. The third regulations, helpfully titled number 3, introduce a new permitted development right for a Class ZA, which also comes into force on the 31st of August 2020. In short, Class ZA allows for the demolition of a single detached building in existence on the 12th of March 2020 that was used for office, research and development, or industrial processes, or a freestanding purpose-built block of flats and its replacement, again subject to certain limitations and an application for prior approval, by an individual detached block of flats or a single detached dwelling house. Again, a means of trying to facilitate increased residential property. Now, the ink on the statutory instruments that I've just outlined was not yet dry before a challenge was issued by a community action group seeking the quashing of the number 2 order, the number 3 order, and the use classes amendment regulations. The claim was brought on 3 broad grounds. The first, that the Secretary of State failed to carry out an SCA, should have done, that the Secretary of State breached the PSED, and failed to take account of consultation responses and other material considerations, including expert reports that it commissioned on numerous specific issues, and issues regarding the proposed reforms, which it's alleged that the Secretary of State adopted an approach which was unfair, inconsistent and or irrational in the context of the approach taken to other similar proposed reforms. The claim has been heard by way of a rolled up hearing, so permission and the substantive claim will be determined in one go. An outcome is expected relatively shortly, the hearing having been heard in recent weeks, so this is one for watch this space. So I've necessarily given only an overview of the changes at a relatively high level in my allotted time. I would advise some colleagues from 39 Essex Chambers have recently presented a webinar which is available on 39 Essex's website, which goes into the change of use changes in more detail as part of 39 Essex's 39 from 39 webinar series, which Stephen mentioned at the beginning of the presentation. Thank you. So I'm now going to hand over to John.
Well, good afternoon to you. I'm not sure whether I've got the graveyard position or I've got the finishing line in sight, but for the next half an hour or so, I'm going to be talking about these particular issues. That's the interpretation of Section 106's, interpretation of planning conditions. Yes, 5-year housing land supply, the jurisprudence continues. There's some interesting topics or topical views from the Court of Appeal as well as the Supreme Court on Greenbelt openness. And then finally, a case that seems to have reached the national press about the local authorities' involvement with what is effectively a neighbour dispute. So let's deal with Section 106 interpretation. Now, as some of you know, I sit as an arbitrator and also act as an independent expert as well as being a planning barrister. And oftentimes I get submissions made to me, particularly in the last 18 months, indeed one from a West Midlands authority, that somehow a more indulgent view should be taken about the interpretation of a Section 106. And sadly, all too often, the drafting suggests that they have been undertaken in a hurry. And oftentimes the submission that is being put forward, which basically comes down to one based upon the public interest trumping construction principles of construction, and the statutory purpose underlying the 106 taking precedence rather than the actual wording in terms of its articulation, should somehow change the approach that I should take as the neutral dispute resolver. And indeed, last year, when we had the Court of Appeal making reference to technical traps, even the suggestion that somehow a local authority had been lured into not including something when perhaps in hindsight they should have done so. So it was not without some interest that I heard about the Norfolk Homes challenge raising these very matters, and its initial hearing before a former colleague of ours, Mrs. Justine Thornton, back in March. The case had added interest because my local authority is none other than North Norfolk District Council, about whom I have written in our newsletter on various occasions, who are as it were, slouches to bringing or resisting litigation in the High Court. But anyway, in this instance, Mrs. Justice Thornton seemed to find it sufficiently attractive that the issue of what could be a technical trap should be certainly the matter of a full hearing. And that came in front of none other than Mr. Justice Holgate back in July. And then a month or so later, we actually had his judgment. And the context in which the matter came before the court was where an initial Section 106 planning obligation required 40% affordable housing. There were subsequent Section 73 variations of conditions, but no tidying up of the 106. So unsurprisingly, Norfolk Homes sought a declaration in the High Court after starting the process through a lawful development certificate, but not pursuing it, that their scheme was free of that Section 106 requirement. And whilst one can understand North Norfolk's motivation for resisting the challenge, bearing in mind the loss of such a significant number of affordable housing units, something of the order of 30 plus, nonetheless, the arguments that were put forward, unsurprisingly, in my view, did not find favour with Mr. Justice Holgate, who in somewhat trenchant terms dismissed the technical traps argument by saying, well, it was never really part of the decision of the Supreme Court in Lambeth. It had been a shorthand used in the Court of Appeal by none other than Lord Justice Lewison, no slouch on the interpretation of deeds, having been a Falcon Chambers QC before coming to the bench and then to the Chancery Division. And I'll return to him a little bit later. But what is helpful is that what the case does, it first of all sets out a reminder about the principles that should apply to the interpretation of deeds forged over 20 years in the House of Lords and the Supreme Court, respectively. It also endorsed the fact that the approach was no different, whether it was a unilateral or bilateral agreement. That's the Hitchens case against Worcester County Council just a couple or more years ago. But where the matter goes further is not only closing this misconception that there should be leniency given to local planning authorities in terms of the drafting of documents, but also the unintended consequences of applying terms into a statutory, a deed itself that has statutory context, but nonetheless is a standalone contractual obligation. And that starts with the whole position of the general public and what they could expect, also taking the matter through to subsequent transfers of title and the extent to which the implication may have a different meaning and significance depending on who is the landowner. So hopefully that particular matter has now been finally put to rest, and whilst in one sense it may lead to a different emphasis in some of the references I received, nonetheless I can sigh with greater relief when I have to find in favour usually of the claimant developer. So let's turn to the interpretation of conditions, and this case, DB Symmetry against Swindon Borough Council and Secretary of State, is of very recent origin. Indeed, it actually got into the Lawtel inbox at the beginning of this week. And again, insofar as the courts are trying to provide greater certainty and clarity of approach, So we have it with this case, and the lead judgment was given by, yes, Lord Justice Lewison in this instance, and he pointed out that in the context in which the matter was being dealt with, there was no difference between, again, the interpretation of a planning condition and any other document that has to be construed in the context before the court. In other words, there's no special set of rules that should be applied. But on the facts, as the matter concerned, a condition requiring the public to have access to the passage of roads, it was the view of the court that that didn't require specific dedication of the road as a public highway. That was something that could be dealt with separately under statutory powers, and there was no need to imply that requirement into that particular wording. So again, some more certainty in that regard. So then let's move on to five-year housing land year jurisprudence. Now in 2019, we had Paul Newman, New Homans, although that's currently awaiting determination of the Court of Appeal, and Waverden, which basically confirmed that just because a plan had expired, the policies weren't automatically out of date. Well, now on Peel Investments, we actually have a definitive view of the Court of Appeal, and whether it applies to the previous version of the MPPF or the current version, that's the 2019 one, which I call MPPF 3, I suppose it's July 2018 precursor. Paragraph 11D, as we now know it, doesn't engage in the tilted balance simply because a plan period has expired. But bear in mind that this was an endorsement of a very robust judgment of the court below, the High Court, Mr. Justice Dove. It was also pointed out by their lordships that even where there aren't strategic policies, it doesn't mean also that a plan is out of date. And in that context, one needs to appreciate that the policy in question was a saved UDP policy, this one ENT, prohibiting development, which would otherwise fragment or detract from openness of a strategic green wedge. So in that regard, certainty, particularly for hard-pressed local planning authorities, and indeed a reminder that at the end of the day, these matters do come down essentially to planning judgment and not matters of law, a theme that we'll see repeated in a moment. So to next, the Greenbelt principle of openness, and the year's offering started with Samuel Smith Old Brewery, that well-known litigant of High Court matters and indeed a good client of 39 Essex, and the Jackdaw Quarry extension permission being granted by North Yorkshire County Council, which became the subject of concern. And the issue, as one can see here, is whether or not it was appropriate for that sort of development to be treated as appropriate development, and indeed, in terms of the contents, whether or not openness was engaged because of the quality of the landscape into which it was going to be extended. And the view of the Supreme Court was no, quality of landscape is not an essential requirement. Thus, those visual qualities might be an aspect of the necessary planning judgment. Nonetheless, at the end of the day, it came down to the particular facts and the viewpoint of the decision maker. Can I just also remind that the case is also helpful on what are material considerations and the extent to which they need to be specifically addressed by the decision maker. So the case is helpful in two respects, although in the context in which I'm speaking this afternoon, it's about Greenbelt openness. Then we have a return to considerations by the Court of Appeal, and again that other reformer of planning case law, Lord Justice Lindblom, Sam Smith being the last outing by Lord Carnworth, and indeed, as you will see in a moment from a subsequent case, perhaps a degree of competition between those two learned gentlemen. But anyway, in Hook, we have an issue in itself seemingly minor about alterations to a building and whether they were appropriate or inappropriate development. And perhaps aside from Lord Justice Lindblom, that these, as it were, green belt terms, inappropriate development, very special circumstances, preservation of openness, etc., are not points of law, but of planning policy. So in the context of what is inappropriate development, it is a matter of planning judgment, and a reminder that the nature of the decision maker's task will differ from one form of greenbelt development compared with another, and agricultural dwellings are cited in that context. So again, another helpful case in trying to provide some degree of structure in the context of determinations, particularly before the local planning authority. And then we have Liverpool open spaces. Now, this case has a number of interesting aspects to it, because it was one of those matters which essentially got resolved by the time we got to the Court of Appeal, but nonetheless, it was the view of the parties, and particularly the court, that it was important that the matters should still be the subject of a full hearing and judgment. And again, in this context, it was looking at greenbelt principles, albeit in the context of green wedge development, which, whilst modest in this context, 39 dwellings being sought by Redrow, nonetheless, applicable GB principles would apply. And the judgment of Lord Justice Lindbrom is helpful because it not only draws from Sam Smith and Hook, but also brings together certainly his view on the jurisprudence in a more complete form, and the extent to which he feels that he was still being endorsed by the Supreme Court. And the important issue that I take out of this particular case is a reminder that, of course, it comes down to realism and common sense about whether you're going to keep designated land free of development, as well as their physical and visual impacts. So hopefully that is the last statement for the moment from the Court of Appeal, but one just never knows. And indeed, as I was putting these slides together, I suddenly realized, of course, that this recent decision to do with neighbourhood development plans, Loch Arlott investments against Mendip District Council and Norton St Philip Parish Council, was also helpful in that regard. But it's in a slightly different context, because there it's dealing with local green space policy in an NDP. And as the lead judgment reminds us, LGS, as they're known, the acronym, were a response to concern that areas of land were being registered as towns or village greens, and it was agreed by the Court of Appeal in the Cooper Estates case last year that the matter should be looked at on the same basis as greenbelts. So it's unsurprising that the concern of the Court of Appeal, although it wasn't of the court below, Mrs. Justice Andrews, that if you were going to restrict national greenbelt policy in the form in which was being proposed here, in other words, that development could only be permitted if it enhanced the original use and the reasons for the designation of the space, that the court looked for a reason justification, could not find any in the papers that had been before Mendip, nor actually could any be found in the examiner's report. And the case is very interesting because it also looks quite carefully, or very, very graciously, at the role of the NDP examiner, the lady in question, Anne Skipper, being noted having had 30 years experience as a planner, and one clearly whose role was being respected by the court to the extent of being similar, although distinct from that of the normal planning inspector, but nonetheless was still not sufficiently discharged with regard to the provision of reasons. So a useful case, certainly one which is also important when one looks at the context in which local planning authorities have to continue to maintain their supervisory jurisdiction over neighbourhood development plans, and of course in the context of the white paper, the extent to which there may be some necessary curbing of the over-enthusiasm given by two past Conservative governments to, as it were, empowering lower and middle England in terms of their planning roles and their community interests in ensuring that what takes place is acceptable to the locals and only to the locals and not the wider public interest. So let's move to two examples. The first is the Eternal Wall of Answered Prayer, which is a national monument which got into the headlines in September following an article in the Sunday Times when, following the grant of planning permission by North Warwickshire Borough Council, in July, and the Secretary of State not calling in the application, or its next door neighbour, the SURF proposal there, emerged SURF, that this scheme could now proceed. And it is in itself really rather magnificent and iconic. I can say that because I was involved with Turleys in the promotion of the scheme, and certainly in terms of architectural beauty and symmetry, it's called a modus strip, and I'm advised that it amounts to perfection because of the particular design and an aspiration dating back to Renaissance times. But enough of that. You will see from the slide that the visibility at 50 meters high is intended to be significant, not only from the M6, M40 and M42 motorways, but also from flights in and out of Birmingham International, and of course from HS2, which runs past the edge of the site. So in this context, how was openness dealt with? Well, in fairness to North Warwickshire, they looked at it in the context not only of the role and function of the green belt here in terms of separation of Solihull from Coles Hill itself, but also the design of the scheme, but also equally the very special circumstances, including the economic benefits that would come to the area by having such a national landmark. And in that context, seeing the catalytic effects of the Angel of the North as being part of that. Also the Commonwealth Games, the need to have this structure up as well, and indeed its adjacent neighbour emerged Surf, which is where they are proposing to host some of the aquatic sports. And then we have also the M42 DCO, which was granted a little bit earlier in May, and the Junction 5A introduction and the Junction 6 related improvements. And again, one sees the issue of national interest and the extent to which visual impact has to be looked at in the context of the extent and function of the green belt in that particular area, and the extent to which preservation of openness can be achieved in effect by a road network, even if there is going to be built engineered form within it, but also a very strong landscape scheme. And you get an indication here from the types of planting proposed at the various parts of it. So let me lose finally, and indeed perhaps as a segue into a last slide, to the case of Hams. Hams seems to have hit the national press because not only the facts are somewhat unusual, but also because of the plea made by the judge in question, the former head of the Administrative Court, Sir Ross Cranston. And the case of Hams arises in this way because Ms. Hams had applied not once, but twice for judicial review against Bath and North East Somerset Council to actually exercise their Section 106, 102 revocation powers. And the context in which the matter came before Baines, but also the High Court, arose in this way. Some years previously, Ms. Hams had actually converted a property into a lodge. It had nice views out over the rolling edge of the Cotswolds, designated AONB. And along comes Ms. Chubb on behalf of the local estate, puts up a fence to keep in cattle from time to time. And the council take the view that they need to take enforcement powers because not only the AONB designation, but also the fact it was above permitted development heights of 2 meters. And the matter went to appeal, and the inspector came to the conclusion that the breach of planning control should be upheld. Now, time passed, and Ms. Hams got no less excited about the presence of this fence, although 300 meters away from the windows of her property, nonetheless did continue to despoil the view and had a marginal effect on lighting to the building in question. So she sought to persuade Bath and North East Somerset, who declined to exercise their powers. An initial judicial review was taken because of a technical error to do with delegated powers. That was conceded, and then this second JR was brought when the matter still didn't yield the result that she wanted, even though she was prepared to pay the compensation as much as £5,000 in order to see a Section 102 revocation order actually made. And the view of Sir Ross Cranston is really rather revealing, because not only does he go through each of the grounds of challenge promoted by two lady members of the bar, Esther Dallon from Cornerstone and our own Catherine Barnes on behalf of the council, but roundly dismisses each one of them in very articulated terms and coming to the conclusion that they are without merit. Well, where the case also, as it were, struck a chord with me, and wearing my mediator and facilitator hat, was the plea at the end in the postscript, where, having noted that Miss Chubb had put in written submissions saying that she would be prepared still to have a constructive discussion with Miss Hams, the judge points out that a negotiated settlement would be to the public benefit and not just the benefit of these two parties. So in closing, it is to be hoped that not only will that AGR plea take wing amongst other planning court judges, but also with this government at the moment. Boris may have called the current planning system sclerotic, but on the other hand, there are ways and means in which it could be made less hard and rigid, certainly in his view, by a little bit more facilitated conversation and its encouragement through modest changes to the PPG, even before we get to the white paper. So let's think cattle. Let's think of this particular photograph. And it's meaningful in three respects. First of all, because it segues nicely from the Hams facts. Secondly, because sometimes local planning authorities may feel, so in their offices, that they are having to herd cattle. Equally, those appealing also may sometimes think that perhaps local authorities do sometimes look in the wrong direction. And finally, because this particular photograph, taken by none other than Stephen Tromans, won first prize in Chambers Staycation Photographic Competition 2020. So there we have it. We are making very good time this afternoon. Stephen promised a list of cases at the end of this presentation. You will find that in the hard copy of the slides. So that just leaves us, Stephen, to unmute and reappear to answer any questions that may have been received already or are likely to come. And I do note, Stephen, your, as it were, Corona flavored, as it were, symbols around the question mark, but maybe that's just purely coincidental.
No, it's in terrible taste, John, isn't it, as ever? I do have a couple of questions. We haven't had any questions online. It's not too late to ask those. I had one actually, which I think I'll put to not only to Gethin, because I think I welcome your perspective on it. It's in relation to the use classes order reforms. And I think it's been noted that some local planning authorities are talking about or considering ways in which they might be able to restrict uses within particular classes, in particular through, I suppose, planning conditions. So I think it'd be helpful to have perhaps the views of both of you on the law as to that. Is that something that can be contemplated? What are the difficulties in it? Because quite clearly many planning authorities may have quite strong views that they don't want retail to become flats or whatever. Linked to that, I suppose, a further question that occurs to me is the relationship of all of this to local plan policies. You may have local plan policies on uses in urban centres, etc., retail areas, which are all predicated on the prior system of control of use. And where do these changes leave those policies? Would those policies potentially provide any sort of support for restriction by local planning authorities? So I hope that's a reasonably clear question. Whichever you wants to go first, I don't mind, but I think people might be interested to hear your views on that.
Gethin?
Thanks, Stephen. So yeah, in short, the routes open to local planning authority to restricting use within a class are very limited. And that's because, as a flag at the beginning of my presentation, what the use classes order does is make changes within a use class no longer constitute development. So in a sense, they become outside the regulation of development because they are not development. And so it really does remove a great deal of control from the LPA. I mean, that's almost the point, the idea of deregulating the planning system. The limited routes that are open to an LPA to restricting use within a class are twofold. The first is that a planning condition could be imposed. Under Section 71A of the 1990 Act, planning permission can be subject to such conditions as the local planning authority thinks fit. And as the PPF and case law specify, conditions must be kept to a minimum and only imposed where they are necessary, relevant to planning and to the development to be permitted, enforceable, precise and reasonable in all other respects. So whether or not a condition restricting use within a particular use class, so for example within Class E, meet that test, including the threshold of necessity, will turn on the particular circumstances of that individual development. However, I do think it would be really difficult for an LPA to take sort of blanket approach to imposing planning conditions in order to impose restrictions simply as a matter of course, to uniformly avoid the effect of the amendments made to the 1987 order by the 2020 regulations. I think that kind of undiscriminatory approach or non-discriminatory approach is unlikely, I think, to meet the test, depending on the circumstances. The second potential route open to the LPA is by way of potentially planning obligations complementing the conditions, which again could also feasibly be employed where they're necessary to make the development acceptable in planning terms, directly related to development, and fairly and reasonably related in scale and kind to the development. Obviously, Section 106 is only binding us between the particular party and the LPA. Again, similar considerations apply in order to satisfy that necessity threshold in particular. In terms of the local plan policies, well, to an extent, there is a degree to which these changes of use, again, meaning that those changes within a class are no longer development, renders them to an extent redundant. But where I think the local plan policies will be really important is in terms of prospective grants for planning permission for example, Class E. But it is going to mean, I think, to a large part that the degree of precision and, again, control that LPAs are able to exercise both directly through planning permission and then indirectly through local plan policies is just restricted and more limited. As we don't know yet what context this new use classes regime will be situated. It may well be that even around the use classes order, which is a significant deregulation, that even other forms of control and extent to which planning permission is required for particular developments, following on from what may or may not be implemented by the white paper, that it may simply be within even greater deregulatory environment. So in short, I think that the options for an LPA to restrict what would ordinarily have been development are very limited, either through planning conditions, planning obligations, or through the local plan.
Stephen, may I make a contribution?
Please, John. Yeah.
Well, there's nothing new under the planning sun, as it were. And if you remember, when there was all the kerfuffle over office to Resi, a number of local authorities immediately imposed Article 4 directions, and certainly that is the power which, of course, they have. The challenge is the extent to which now they would have to get Secretary of State's endorsement of the use of that power. Previously, it was an absolute. Now, it's more qualified. So that's the starting point. But what underlines, I think, the whole approach is not only a fact-specific one, but also the extent to which the local authority can actually give justified planning reasons for taking a different approach. So obviously, one's expectation is that one finds that in development plan policy, even if it's emerging development plan policy. But as we know, emerging development plan policy takes some time to emerge. So I think one would have to look at the particular situation at the specific time the decision is being made. Now, breaking that down, let's deal with 106s, because as you know, under Reg 122, if it's going to be a reason for granting planning permission, then of course it has to meet the tests. But let's also still remember that you can enter into a covenant that's still binding, which doesn't meet the Reg 122 requirements. And oftentimes I have had to deal with that sort of situation myself professionally. So a local authority could say, right, we'll grant you consent, Mr. Developer, if you enter into this 106. And of course, as we know, trying to get it modified later, after sort of sitting out the 5 years, unless they are prepared to consent to an earlier change, is still challenging, and the jurisprudence on that doesn't help. Now, moving to planning conditions, again, you're absolutely right, Gethin, those tests have to be satisfied. And we know from previous attempts to limit, for example, domestic PD rights, an inspector has always wanted specific reasons as to why it's inappropriate, to remove the ability to hang your washing and things like that. And of course, that can often be justified in grounds of visual amenity. But in the context that we're talking about here, there is an argument which I think could even find favour with an inspector, that if you're changing the nature, for example, of a high street, that it's inappropriate so to do, or as one sees sometimes that what is going to be provided doesn't meet, as it were, normal standards in terms of development control by way of daylight, sunlight, things like that. And I know that's one of the reasons why they closed the light industrial to Resi loophole at the end of September. Well, it's not loophole as such, but PD right. And in fact, it was seen by some as a loophole, but as others as a means of providing necessary accommodation. And I had to advise on something just before the deadline to do with homeless persons accommodation. So sometimes the justification is a very, very good one. But at the end of the day, I think it comes down, Stephen, to the reasons the local authority are prepared to put forward and to actually stand by if needs be at appeal. Thank you very much.
Thanks, John. Yes, I mean, I suppose the proof of the pudding is going to be when we start seeing appeal decisions coming through, isn't it, on
Yes.
These cases. I sort of feel, when I started learning about the use classes order, wonderful things in it, like, horse hoof glue boilers and purveyors of cat's meat and, donkey flayers and all sorts of noxious.
Oh, you're a general industrial chap.
Lost all of that, I'm afraid. But anyway, there we are. Sic transit gloria. John, could I ask a couple of things of you? I mean, one is, you say there's nothing new under the sun, planning sun. We seem to have been arguing about the concept of openness for decades, if not sort of centuries now. Is there any end of this? Have we reached a period with these cases of some sort of equilibrium and certainty, or what remain the issues, do you think?
Well, one would have thought so.
Yeah.
You've had the finest brains in the land having a go at it this year, and what finer pair they can have than Robert Carnworth and Keith Lindblom. And you might as well include Kim Lewison in that as well, because he seems to do a double act with Keith Lindblom in terms of the planning cases. I would hope so. I mean, that's why I think Liverpool is so helpful, because it comes down to common sense rather than this artificiality that sometimes is applied. But I think where it is going to continue to outwork is, as we saw with the three examples cited this afternoon, where you have, as it were, special projects, the extent to which local authorities and other decision makers are going to either get hung up or manage to, as it were, drive over, pun slightly intended in respect to M42 Junction 5A, this issue of openness. And of course, again, one's looking inevitably at visual quality. And as we know, several Greenbelt reviews, and indeed one which was under the Labour government, said, well, if they're in different parts of the Greenbelt, serving really no purpose other than physical separation, maybe they need to go and be developed. And certainly, as you know, Stephen, sustainable development sometimes is better achieved by just taking out a little bit of the Greenbelt. But on the other hand, of course, there's an exceptionality that still has to be established in policy terms. And so I would have thought the safeguards are sufficiently there. Middle England does not need to worry that we're going to concrete over the whole of the green belt, but at the same time, I do think we need to take slightly more rounded views about these particular issues. So I think the courts will say, no, thank you, we're not going to grant you permission, and it's going to have to be something very, very special. So that may mean that even the battles up in Tadcaster may have to be, as it were, refocused, but one never knows.
Okay, John, that's really helpful. Thank you. I think I'm told that someone has raised a hand, but it's not possible, I don't think, on the system we have for people to actually speak. So if you do have a question, if you wouldn't mind going to the Q&A facility at the bottom of the page, should be at the bottom of the page, or maybe depending on what you're using, maybe at the top. But if you type in a question, then we'll pick that up. While we're just waiting to see if there is a question, John, on your closing point about ADR and mediation.
Yeah.
If someone has, if a client has got, or planning consultant, whatever, has got a real desire to go down that route, which is eminently sensible in many cases, can you give people a few tips on sort of where to look, where are the resources on this, places people should go to see what's available, the pros and cons of it, etc.?
Well, if one does a Google search, you come up with an article on planning and mediation that I co-wrote with the chair of the all-party parliamentary group on ADR, John Howell MP for Henley, and indeed one of the original authors of the NPPF, along with Sir Bob Neal, another promoter of mediation. But if you dig deeper, there was a report that was produced in response to the Killian Pretty Review, which suggested that it would be a good idea to have it. That is found on the National Planning Forum website. But really these days, Steve, it's far better to look to Scotland, because last year they introduced Section 40 of the Planning Scotland Act, which introduces a new provision into their Town and Country Planning Act, specifically requiring the use of mediation to be promoted at all levels. And certainly I've been in conversation with people up there, and indeed there's a very interesting webinar that I participated in back in May that's on the Chartered Institute of Arbitrators website, the APPG, in which Graham Boyack, who has been looking into this in Scotland, talks very eloquently about how it's going to be used in Scotland, right through the development plan process through to enforcement. But if I can just mention something, I mean, Section 102 is very interesting, because I've actually literally within the last week, and I've got to go up north on Thursday, I've got other reasons to be up there already, two parties have independently raised whether mediation can be used to overcome the time delay on a Section 102 revocation, which could save hundreds of thousands of pounds and also bring far more certainty to bear. So I think in terms of mediation, whichever document you look at, including the Civil Justice Review publication in November 2018, it all talks about saving time, saving money, improving relationships, which is what I would have thought, if I may boldly say back to Boris, if you're going to change the sclerotic planning system, how about just trying, first of all, to do a little bit of tinkering and adjusting before having comprehensive review. But I might also add, Stephen, I think if they're going to bring in these three categories, they're going to need some sort of brokering service to as it were, speed up the process of transition and change. And the same with building design and quality as well. So I think there's a real role to play. And certainly if anybody wants to get in contact with me, I can very happily give them some further, as it were, reading, both from my own library, but also from web links. But thank you for the invitation.
Thanks very much, John. Well, it'll be fascinating to see how that pans out in Scotland in the coming years. But I mean, for anyone who doesn't know John, he's probably the foremost expert we have on this subject in the planning context. So if you do need to discuss it with him, I'm sure contact him via Chambers. He'll be delighted to help. So I believe we have any questions left. So if we don't, I'm proposing we'll call a halt there. As I said, this will be available from tomorrow, I think, on our website. So if there's anything you missed or you want a colleague to be aware of it, please let them know. And just again to refer you to our website, where there is a wealth of resources, not just on planning, but property issues, if you're interested in those, construction, pretty much everything under the sun. We don't do family law, but I think most other things probably covered somewhere. So I hope anyway you've enjoyed listening to this, watching us. I'm sorry that it's not sort of an interactive live audience. John and I have been doing these things since about 2001, I think, or 2002, every year, sometimes in chambers, sometimes out in the various regional capitals, cities. And it's always so nice to actually see people in the audience, have a drink with them afterwards. And I'm very sorry we can't do that on this occasion, but let's hope that next time we have one of these regional events in the West Midlands, we might be able to do it in something other than this. But in the meantime, anyway, do get in touch with us if you have any further queries. I hope you enjoyed it. Stay safe and well, and I wish you all the best for the rest of the week. So it's cheerio from all of us, and thank you for tuning in. Bye.
Thank you. Goodbye.